Hey everyone, welcome back to the channel. In the case of Su Emmanuel, the Court of Appeal dealt with a property dispute involving a family and the complex interplay of legal ownership, equitable rights, and financial contributions. This case revolved around a property purchased in 1995 by Su and her husband Philip as joint tenants. Philip financed the purchase and serviced the mortgage, while his wife Su made no financial contributions. In 2002, Philip faced financial difficulties and sought help from his sister Priya, who eventually purchased a 49% share of the property, leaving Philip with 1% and Su with 50%. Priya contributed significantly to the mortgage repayments. Priya argued that a sale was necessary due to her financial difficulties, including impending bankruptcy, and that she should be recognized as holding a 70% beneficial interest in the property, reflecting her financial contributions to the mortgage payments and to the property. On the other hand, Su resisted the sale, relying on Clause 10 of the sale agreement, which she interpreted as granting her the right to remain in the property indefinitely. Su also argued that Priya's beneficial interest should be limited to her registered share of 49% and invoked promissory estoppel, claiming that she had relied on representations made by Priya and Philip to her detriment. The court held that Priya was entitled to an order for the sale of the property. The Court of Appeal reasoned that the parties' relationship deteriorated significantly, which made continued co-ownership unworkable, and that Priya would face significant prejudice if the property was not sold, including the risk of bankruptcy. While Su argued that Clause 10 prevented Priya from seeking a sale of the property, the court found that the clause only prevented eviction, not the sale of the property. The court also rejected Su's argument of promissory estoppel, finding no evidence of detriment suffered by Su as a result of the alleged representations. Regarding beneficial ownership, the court determined that Priya's interest remained at 49%, as no resulting or constructive trust arose to alter the legal ownership. However, Priya was entitled to equitable accounting for her significant financial contributions to the mortgage. Now listen carefully. The Court of Appeal provided guidance on the factors to be considered in deciding whether a sale should be ordered. First, in deciding whether it is necessary or expedient for a sale to be ordered, the court will conduct a balancing exercise of various factors, including the state of the relationship between the parties, which would be indicative of whether they are likely to be able to cooperate in the future. The court will also consider the state of the property and the prospect of the relationship between the parties deteriorating if a sale was not granted, such that a clean break would be preferable. Next, regard should be had to the potential prejudice that the various co-owners might face in each of the possible scenarios, namely if a sale is granted and if it is not granted. Finally, a sale would not generally be ordered if to do so would violate a prior agreement between the co-owners concerning the matter in which the property may be disposed of. Based on these factors, the Court of Appeal agreed with the trial judge that the property be sold for the following reasons. First, Priya and Su have not been on speaking terms for more than a decade, making it difficult to see how the parties would be able to cooperate if they were to remain co-owners of the property. Most of the discussions on the issues concerning the property were conducted through Philip, who is himself estranged from his own wife Su. The already difficult relationship between the parties will only worsen if Priya is made bankrupt because of Su's refusal to cooperate, either in selling the property or otherwise addressing the prevailing situation. The Court of Appeal also noted that the prejudice that Priya would suffer if the property is not sold significantly outweighs the prejudice that Su would suffer if the property was sold. The Court of Appeal noted that Priya had spent a huge part of her income and savings on the property, and her interest in the property is at least 49%. Indeed, the property appears to be Priya's principal asset. Su, on the other hand, accepts that she made no financial contribution to the property. If Priya is unable to realize any value from the property, she would be most likely made a bankrupt. Furthermore, despite making the mortgage repayments under the second mortgage, Priya did not occupy the property and continues to live in a rented HDB apartment. As you can see, this case underscores the importance of clear agreements and equitable principles in resolving property disputes. The court emphasized the need to balance the interests of all co-owners while considering factors such as financial contributions, agreements at the time of the acquisition, and the parties' intentions. It also highlighted the potential for equitable remedies such as equitable accounting to address imbalances where one party has shouldered an undue financial burden. That's all for today. Thanks for joining me in this discussion. Don't forget to like, share, and subscribe, and I'll see you in the next video.